One of the most important things that you need to learn if you want to start your arbitration practice is learn how to get an arbitrator appointed. Well, when the parties are agreeable to a person suggested, there's no problem at all. But in scenarios where that does not work out, parties have to file applications before the jurisdictional courts and get the appointment done. Now, this might happen in three specific situations. Number one is where parties either fail to agree on a procedure for appointment of arbitrator or fail to appoint one arbitrator if the procedure is already in place. Number two is that if the arbitration agreement provides for appointment of an arbitrator and parties fail to reach at a consensus within 30 days of request by one of the parties for appointment of the arbitrator. Lastly, if the agreement provides for appointment of three arbitrators and two appointed arbitrators fail to reach at a consensus on appointment of the third arbitrator. The manner and procedure itself is given under Section 11 of the Arbitration and Conciliation Act. In case of a domestic arbitration where both parties are Indians, the petition will lie before the High Court where the seat of arbitration is situated. Interestingly, the Act is not providing a format for a Section 11 application, and therefore, to learn how to draft a Section 11 application, I will be taking you through a fact scenario. We will understand that facts and then learn drafting of a Section 11 application in this video. As you can see on my screen, this fact situation is about a company called The Amazing Corp. It's based in Bangalore and it's a multinational retail giant which is engaged in procurement and storage for distribution of vast number of online customers. Now, they did an agreement with Ready to Move Co. in the year 2023. Now, this is a team based out in Delhi. Their agreement stipulated an arbitration clause, which is clause 8.1 of their agreement. It says that, of course, if there is a dispute between the parties, they will first try and solve it through mediation. If that does not work out, parties will refer this to a sole arbitrator. Within 30 days of the receipt of the written notice from either party invoking arbitration, the party shall use their best efforts to mutually agree upon a sole arbitrator. Okay, they have specified that the seat and venue is Bangalore, the language is English. Now, what has happened? In the last few months, they have been complaining about Ready to Move Co's slackness. There have been repeated breakdowns. Ready to Move Co has been assuring, but they have not been able to deliver. Now, there is a dispute that has arisen between the parties. Due to this dispute, what has happened? Amazing Corp has withheld payments to Ready to Move Co. And in turn of that, Ready to Move Co. has suspended its transport operations. The parties did try to mediate amongst themselves. There were 4 sessions, but all of them failed. Notice to appoint arbitrator was given and appointment of Mr. X was proposed. But this did not happen because they did not agree on nomination of Mr. X. Therefore, we are going to go under Section 11 and file an application for appointment of arbitrator. Let's see how that looks like. As you can see, the first thing that we will mention is the title. So we are approaching the High Court of Karnataka. Now here you can see that the arbitration clause specified that the seat is Bangalore, and therefore this is the High Court which has jurisdiction to hear the matter. Then we have stated that it's in the original jurisdiction, arbitration petition number so and so. Now this nomenclature may change from one High Court to another, so you have to keep a tab on that. Then we go ahead and we write the names of the parties. So this is Ready to Move Co, who is the applicant, versus the Amazing Corp. You can see here we've inserted the details of the parties along with their authorized representatives and their official addresses as well. Now we are filing this under Section 11.5 because this is for appointment of a sole arbitrator. Therefore, we are going and invoking subsection 5 here. Okay. Along with that, we have an arbitration clause. Therefore, we are saying this is filed under Section 11.5 of the Arbitration and Conciliation Act, and it is read with clause 8.1 of our original agreement. Here, in the introductory paragraph, we're mentioning a standard clause that we are filing this under Section 11.5, and this case falls within subsection 5 because we're asking for appointment of a sole arbitrator. How does the draft look like? The petitioner is filing this application under Section 11.5 for appointment of an arbitrator to adjudicate the disputes between petitioner and respondent. This is arising out of agreement dated 15th of September 2023. Then we go on to the facts. We say who Ready to Move Co is, and we talk about who Amazing Corp is. So we've mentioned the details of the parties and the businesses that they do. We say that there was an underlying agreement. We speak about what the nature of the agreement was. So it was relating to transport. And it is very important, like I have mentioned here, that it is important to annex this in totality, as your arbitration clause is in this very agreement. So you have to annex this. Don't forget that. Then we say that, yes, the contract contains specific terms regarding payment and delivery and transport of goods. We talk about the fact situation in detail here, how the contract was being performed in 2023. Then there were repeated disruptions. Then there were sureties given by the respondent, but they were not able to address it. Therefore, the petitioner had to withhold certain payments, and then transport services were suspended. So we talk about the fact situation in detail here. Through the set of facts, you need to ensure that you are telling the court that yes, there is a dispute that exists between the parties, and that's what we have done here. Then we talk about the fact that the dispute between the parties remained unresolved after several attempts of mediation. The logic behind writing this is that it is a precursor to arbitration process as per our own agreement, and we need to follow it. Then we go ahead and talk about our arbitration clause. So I have reproduced the clause, and like I have written in the hints that you need to reproduce it in its entirety. Then we say that we do not have any alternative. After mediation, what did we do? We sent a notice for appointment of arbitrator to the respondent on 15th of June. We proposed appointment of Mr. X, and we have annexed the true copy. The logic behind this is very important, that to invoke a Section 11 petition, you need to send a notice under Section 21. So you have to mention this in your petition in a separate paragraph. We say that the respondent, despite due service of notice, failed to respond. Now, this 30-day, like I have written here, the logic is a statutory limit. Only on expiry of this period can a Section 11 application be moved. So you have to mention this positively. Now, we say that respondent's non-cooperation was there, and therefore we have invoked Section 11(5). We add this clause for the purpose of appointment of a sole arbitrator. We say that, yes, we did invoke arbitration, and due to respondents' failure to cooperate, we are constrained to approach this court under Section 11(5). We go ahead and write a paragraph that we propose appointment of Mr. X. Then finally, moving to the prayer, we say that, yes, we want an appointment of a sole arbitrator to adjudicate the disputes between the parties and any other orders that this honorable court may deem fit. Now, this is a standard template. You can go ahead and tweak it as per your own fact situation, and it works out really well. It looks easy, right? It is, in fact, very easy. It's exciting. And the best part is it's financially rewarding. So do you want to learn more such skills? Well, you should definitely come and join our 3-day online free live bootcamp. Now, this is a 3-day bootcamp on corporate litigation and arbitration. It's happening on 27th, 28th, and 30th of July, 2024. You would not want to miss out on this opportunity, and we are going to teach you some invaluable skills. So don't forget to mark your calendar. No recordings of the session are going to be available. It's only live, so don't forget and don't miss out. I will definitely see you there. Bye.